Good afternoon and welcome back to the Supreme Court of the United Kingdom. We are continuing hearing the submissions of Mr. Diwan on behalf of the respondents. Mr. Diwan.
My Lords, thank you. Just coming back to the point that Lord Sales raised prior to the lunch interval. If we can go to the FDA at page 372 and 373, first 372, just in terms of areas where UNIDROIT could apply, 3.6c, renewal of the grant, the renewal of the license, in other words. If you look at 3.6c, it says there are various conditions. One is that the licensee is maintained throughout the period of the initial grant at each outlet developed under this agreement a minimum hospitality quality service and cleanliness average pursuant to criteria established by licensor. And it refers to Schedule A, and you'll see that Schedule A, which is at page 384, simply says 85% HQSC. Now, one would have thought that in terms of how the criteria, which is very loosely defined, that would be an area where UNIDROIT could supplement. I would say the same in Article 4. If you, the last three lines, the parties agree that additional outlets may be opened by licensee only if such additional outlets are approved by the licensor, such approval not to be unreasonably withheld. There's a discretionary function there as to approval and not being unreasonably withheld. One would have thought that UNIDROIT could supplement there. Article 5.1, the last two lines, last three lines, the final decision as to the acceptability of any proposed sites rests in the sole and absolute discretion of the licensor. My Lord.
End of your examples. You pointed out that Article 2 contains a general good faith requirement in the contract, quite apart from UNIDROIT anyway. So I wonder, in relation to that one, to what extent UNIDROIT would be adding anything to the contract?
Save to the extent that good faith extended beyond the good faith in Article 2, my Lord. Good faith under UNIDROIT.
All right, thank you very much.
Mr. Dewan, I wonder whether that provision you're addressing could have been intended to deal with a situation where there's a non-liquet, where the arbitrators might find that there is no law within the system referred to which is capable of addressing the particular problem which has arisen. Now, that's not something we're familiar with in this jurisdiction, but in certain other legal systems, sometimes the judges have to say there's no applicable law that we can apply.
My Lord, I would entirely agree. That was what I was humbly trying to, but probably not adequately saying as being my proposition, because when one looks at UNIDROIT and one looks at the introductory comments to it, as to it being used in some legal systems as a supplement, where the legal system is not necessarily that developed, it seems to me that was potentially one of the reasons for the inclusion of this provision. Obviously, I can't speak to the genesis of this clause and whether it was boilerplate language. In other words, because this isn't the only franchise agreement that may have been entered into and so on, or if this is a sort of used for different jurisdictions and so forth. but it's certainly possible that in some jurisdictions, UNIDROIT would have a much stronger gap-filling role for dealing with problems that have not been addressed than might be the case under English law.
Thank you.
My lords, the next point that I have two issues remaining. The next issue is application of the summary judgment test to the facts, and whether there's anything left to argue, as Lord Legate put it. Now, there are a number of points here. The first question is to be addressed by the court is as to the prospect of additional documents materializing to support the estoppel case. The Court of Appeal at paragraph 85 considered that this was a fanciful prospect or it referred to Mr. McCorber's hope that something would turn up. And the point in my submission is what is also said at paragraph 85, page 288 of the electronic bundle, which is that the criticism that the Court of Appeal made was that no attempt was made to particularize what further evidence might be available or how it would satisfy the ROC advertising test. Now, I focus on that for this reason. As is well established as a matter of legal principle, the appellants cannot simply make an assertion as to the existence of other documents or that something will turn up. There must be reasonable grounds for believing that a fuller investigation of the facts may add to or alter the evidence relevant to the issue. And if authority is needed for that, obviously the Supreme Court in 2019 repeated a well-established proposition in Lungau against Vedanta Resources, 2019 UK Supreme Court 20 at paragraph 45, which is at page 1714 of the bundle. Now, the relevant issue, as we've already identified on my case, is whether there is evidence going to a representation by conduct that is distinct from and goes beyond the alleged promise that is said to constitute the informal agreement. So they have to articulate a case and identify documents that may exist or they have a reasonable basis for believing exist. Now, the problem is that there is, my lord.
Just on a question of information, in the arbitration, did your client take part under protest, as it were, and
Yes, my lord.
So that there was full evidence and indeed disclosure? Was there in accordance with the ICC rules?
I was just coming to that point. That was my first point in terms of what further material or documents could there be. There has been a full ICC merits hearing after the exchange of 4 memorials, heavy memorials, multiple witness statements, expert evidence, and disclosures by the ordinary Redfern schedules, requests, and so forth. And of course, the award contains an analysis of the conduct relied upon by the appellants, which is to be found in the award at paragraphs 171 to 192, which is pages 452 and following of the electronic bundle. Now, so that's the first point, that there's been a full merits hearing following a full ICC arbitration leading to a 4-day evidentiary hearing, which lasted over 2 years. And that was one of the compelling points which the Court of Appeal found difficult to comprehend, how there could be other documents in those circumstances. And of course, if there are documents relating to a representation, they are by definition going to be in the possession of the appellant because they're going to pass between the parties. Now, there of course has been a 3-day hearing at first instance and a 2-day hearing before the Court of Appeal. And the conclusion reached by the Court of Appeal and at first instance, and this is summarized at paragraph 80 of the Court of Appeal judgment at page 287, was that the appellant had not advanced a case going beyond the alleged performance conduct said to constitute the agreement and amounting to the unequivocal representation that the alleged promise was valid notwithstanding its informality. Now, in my submission, there's no basis for saying that this assessment was vitiated by any error of law. What we can see in the appellant's written case, paragraph 65 to 84, is a repeat of their factual allegations of conduct in the period of 2000, from the period 2006 to 2011, concerning alleged performance of the agreement. Now, those acts of performance are relied upon as the informal promise, but they're all the same acts of performance are relied upon as giving rise to the estoppel, and that is where the error of legal principle arises, which is why the Court of Appeal granted summary judgment. Now, what is said is, well, and this was said to the Court of Appeal as well, and that there are invoices from the appellant charging the respondent, invoicing the respondent for royalties due under the license agreement. But that is not new evidence. The documents themselves were not physically before the court. But what was physically before the court and is before the court today is a schedule of the payments made by the respondent, which we say were on behalf of AHFC, but leave that aside. But the payments themselves, in other words, the only conduct of the respondent that is relevant has always been there. The invoices are not conduct of the respondent. Whether one can have a debate as to whether they constitute reliance by the appellant, but that's irrelevant to the issue of conduct by representation by the respondent. The respondent's representation and conduct is through its payments. And the problem with their reliance on the payments, which is in these paragraphs 65 to 84, was before the tribunal, that's all part of their case of continuing of conduct giving rise to an informal promise. It's embedded within it. Now, if they had wanted to, and I say it's too late for them to do so, if they had wanted to, and they'd been given plenty of fair warning, they would have needed to delineate their case between the conduct said to constitute the informal promise and the conduct said to constitute the separate representation. And the reason why they have never done that is because it's going to create an incredible difficulty with them and put their informal promise case to proper scrutiny. At the moment, their informal promise case is this vague allegation stemming all of the events between 2006 and 2011 without any identification of when the actual informal promise actually happened, when it was made, or its terms for that matter, as Sir Michael Burton identified and criticised at first instance. And just to give you one example, and I hesitate to go to documents, but I just want to give you one example, which is if we take the year 2006, for example, which they've never committed to, they say that the informal conduct began in 2006. In 2006, if your lordships pick up, for example, this was a point I made to the Court of Appeal as well, page 686. This is a franchise outlet agreement which was entered into on the 17th of July 2006. And you're pursuant to the FDA. You'll see that the signatory parties remain Kabab-Ji and AHFC. And this isn't the only franchise outlet agreement entered into in 2006. There are others in the bundle. There's another one at page 661. And there's another one at page 698. So the point I'm putting, without getting into the detail of the documents, because I'm not sure the basis on which this court would be reviewing that, save in the event there's an error of principle. The reason why I'm putting it is to the point that they have specifically chosen not to delineate between their informal promise case and their estoppel case, because that creates its own problems for them. And it would put the informal promise in my submission to further summary judgment scrutiny. But as it is, their case is one of continuing conduct said to constitute both the informal promise and the unequivocal representation. And that's why it's been rejected. So in my submission, the invoices are nothing to the point. They make absolutely no difference to the relevant issue. My lords, that was all that I was going to say on application to the facts. And I was going to now turn to this question of adjournment. There are two aspects to the issue of adjournment. One is the question of adjournment and whether it's actually a live issue, given that the Paris court has given its decision. And the second issue is the issue raised in written submissions, which is that this court should, in any event, take account of the French court's decision. I mean, strictly speaking, it's not within their grounds of appeal, but I was proposing to deal with that because there's an attempt to rely, as I alluded to earlier, on the Minmetals case for the proposition that you should have regard in the exercise of the discretion whether to recognize or refuse recognition. The court should now have regard to the Paris Court of Appeal's decision. So I was going to address both of these points in order. My lord, on the question of adjournment, obviously we are talking about the discretion of the court under Article 6 of the New York Convention, enacted in Section 1035 of the Arbitration Act. And the starting point is obviously that the appellant has to identify an error of principle or significant error in the considerations taken into account or not taken into account for the purposes of inviting the Supreme Court to re-exercise the discretion under Article 6. And authority for that proposition is VTB Capital against Nutritech International, 2013 2 appeal cases 337 at paragraph 69, which is in the electronic bundle at page, my lords, apologies.
Oh, to be fair to the appellant, aren't we actually deciding whether the Court of Appeal was entitled to interfere with the judge's discretion? Because did he not actually grant an adjournment?
My lord, apologies. I should have put it more fairly than that. Your lordship is right. Apologies, my lord. Let me put it that way. Whether the Court of Appeal was right to interfere with the exercise of discretion. Now, I've largely dealt with that, subject to one issue. So I've largely dealt with it in this sense, which is that the error that the Court of Appeal identified was that, having determined that there was no, and your lordship will appreciate that Sir Michael Burton did make a determination that there was no real prospect of success. That hasn't been, the way it's been portrayed by my learned friend, might think that Sir Michael Burton did not make that sort of conclusion. But at paragraph 68, page 353, the last sentence, the conclusion was, as it is, but for my having given a last chance to the claimant for the reasons I have given, I would have concluded that, as against KFG at English law, the claimant has and ought to have no prospect of success in enforcing the award. Now, the last chance was granted on the basis that there might exist more documents. And the proposition I put to the Court of Appeal was that, well, an assertion of that nature cannot go untested. There has to be a real basis for believing that a fuller investigation or the existence of documents will make a difference. And that's where the Court of Appeal disagreed and interfered. That's the basis on which the Court of Appeal interfered with the exercise of, well, that's the first basis on which they interfered with Sir Michael Burton's exercise of discretion. And we can see that at paragraph 84, page 288, where the Court of Appeal says it's obvious from the judge's findings that on the material before the judge, there was no such prospect given the appellant cannot begin to satisfy the ROC advertising test. The error in the judge's approach is nonetheless granting the adjournment is that he did not seem to give any consideration to what additional material evidence would or might emerge during the proceedings before the French court or otherwise, before any further hearing before the commercial court, which would give the appellant a real prospect of satisfying the test. So in my submission, I've already effectively dealt with that point when I've applied the summary judgment test to the facts. In my submission, the Court of Appeal was entirely correct in its assessment. The second point, though, which the Court of Appeal made, which is at paragraph 81, is that, well, what value would an adjournment, what use would there be in an adjournment, bearing in mind the determinations that English law applied to the FDA's arbitration agreement, and that the French court was going to be applying French law. And an entirely different concept. And that's the point of paragraph 81, which the Court of Appeal makes. when it says the French court would not be applying Article 5.1a, but internal French law. And so it effectively interfered with the discretion, the discretionary exercise of Sir Michael Burton on two grounds. One is it was an exercise, effectively it's an exercise in futility, because they're applying an entirely different approach under a different law. And secondly, there was no real prospect of success in establishing the rock advertising test on a fuller investigation of the facts. Now, so my submission, the court was entirely right in that, in coming to that conclusion. And I have cited in my written case various jurist articles from Poudret-Besson on the possibility of conflict between a decision of an enforcing court under the New York Convention and the supervisory court applying different principles and rules. And the point that they both make, and I'm going to take you to them in a moment, is that you cannot reconcile the irreconcilable, and you just have to accept that this is an exercise in sovereign power by different legal systems applying different legal principles. So if I just can briefly take your lordships to both of those articles, Besson, The International Effect of Award Judgments, at page 1910, under the heading Impact of the Question of Applicable Law, what is said is, at the second paragraph, it is indeed important to keep in mind that the same issue may be governed by different laws depending on the judge or authority hearing the matter. This is not an inconsistency, but rather the result of the world being divided into sovereign states governed by different legal systems. This applies in particular to the arbitration agreement. And then in the last paragraph, in such a case, an award judgment rendered in one or the other state would have no international effect in another state, because the question asked is not the formal validity of the arbitration agreement, is not subject to the same requirements and subject to different laws. Even under the broad concept of res judicata and laws of common law tradition, issue estoppel presupposes that the same issue arises, which is not the case where the requirements of applicable law are different. So, and the same point effectively is made, and we don't have to look it up, in Poudret-Besson Comparative Law of International Arbitration at page 1853. So, in my submission, the Court of Appeal was entirely right to say, well, what is the purpose of an adjournment in these circumstances? And your Lord, going back to our articles, my Lord.
I think I'm right in saying that part of what the New York Convention did, in compared with, I think, was the Geneva Convention before that, was in more scope, or in some circumstances, enforcing arbitration awards, even if they might have been, for example, found to be unenforceable by the law of the seat.
My Lord, indeed.
You know, it's inherent in the scheme of it that you don't need to establish the validity in the place of the seat in order to seek recognition or enforcement of your award.
Yes.
Which contemplates that sometimes the two may come apart, as it were.
My lord, indeed, it removed the double exequatur, as your lordship is putting to me, and it's inherent. Of course, there is no ground within the New York Convention, for example, and this comes to the second point of my learned friend. There is no ground in the New York Convention to say, well, because the court of the seat has refused to set aside, that the enforcing court, there's no ground to say that the enforcing court therefore should recognize. That a fortiori follows from what your lordship has just put to me, which is the removal of the double exequatur. Your lordships may be interested in that context, in the negotiating history of Article 6, which is at page 1326 of the bundle. So this is, I referred to this document earlier. The heading is at page 1325. This is the summary analysis of record of the UN conference. It's actually the summary analysis of the record of the negotiations giving rise to the New York Convention. And what you will see at page 1326, at the bottom paragraph, it was suggested that the conference might wish to consider 3 possible alternative methods of control. That means control over the award. It might first be provided that sole judicial control over regularity of an award would be exercised by the competent authorities of the country of enforcement. A second alternative would be to divide judicial control between the authorities of the country where the award was rendered and the country where enforcement was sought, by enumerating the grounds on which the award would be annulled by the former and those on which the enforcement could be refused by the latter. That obviously didn't happen. A third alternative would be to leave full judicial control in the hands of the authorities of the country where the award was made, which also didn't happen. And then it goes on the next page. After considerable debate, the conference came down mainly on the side of the first of these alternatives, i.e. primary control with the enforcing court. At the same time, it did not prohibit judicial proceedings at the place where the award is rendered. It recognized that if an award is suspended or set aside by a competent authority in the country in which, or under the law of which the award was made, recognition and enforcement may be refused. But of course, that's the opposite situation. So in other words, basically, and you can see that from the scheme of the convention itself, essentially, primary judicial control is with the enforcing court, subject to a discretion to refuse recognition and enforcement where the award has been set aside by the courts of the seat. And that then feeds into the question of the relevance of the French Paris Court of Appeals decision for this court as the enforcing court. Now, in my submission, all it amounts to is an attempt to prioritize the French view over the English view, for which there is no basis in the New York Convention. The only basis on which one could take account of the French court decision is if there was and I'm going to take you to the Supreme Court in Dallas on this, but there has to be a recognizable legal principle by which the foreign court decision could be taken into account. And I do need to take you to Dallas on this because it's quite important. And that's at page 1598 to begin with. This is, I'm looking at paragraph 67 to 68 of Lord Mance's judgment in Dalla, and he's dealing with discretion under the New York Convention, as you can see. And he's talking about, and he's addressing at paragraph 68, the discretion and the use of the word may in Article 5. And what he says is, in the last 4 lines, absent some fresh circumstance, such as another agreement or an estoppel, it would be a remarkable state of affairs if the word may enabled a court to enforce or recognize an award which it found to have been made without jurisdiction under whatever law it held ought to be recognized and applied to determine the issue. So the reason why, and Lord Collins said made a similar point at paragraph 127 on page 1615, and there he's referring to Lord Justice Mance, as he then was in Dodania and UKAS, as Lord Justice, and I'm reading from the middle of the paragraph, as Lord Justice Mance emphasized at paragraph 18, there's no arbitrary discretion. The use of the word may was designed to enable the court to consider other circumstances which might, on some recognizable legal principle, affect the prima facie right to have an award set aside arising in cases listed in section 103(2). And the difficulty, which comes back to the exercise of the discretion, is the fact that you can't have a recognizable legal principle, such as an issue estoppel, where you're approaching the same issue on a completely different basis. So that's why I say there's no basis to take into account the Paris Court of Appeal's decision in the context of this court's consideration of whether the Court of Appeal was right to refuse recognition and enforcement, because there is no legal principle by which the appellant can rely on the Paris Court of decision, which applied an entirely different approach and law. Now, just on this, and just to finish this point off, my learned friend does try and rely upon the Min Metals case, Mr. Justice Coleman's decision, to suggest that you can take into account a foreign court, the supervisory court's decision in the exercise of discretion. Now, in my submission, as was held equally by Mrs. Justice Cockrell, and I'm going to take you to that case in the Cat Left Against Ukraine, which is at page 2470 of the bundle. The Min Metals case is an entirely different type of situation because it was concerned with public policy, and it's been confined to public policy by Mrs. Justice Cockrell, as I'm going to take you to. But first, let me take you to Min Metals, which is to be found at page 1488. The relevant passage is at 1488. So let me just explain what this case was about, just to put it in context. The court was addressing the question of whether an English court should refuse recognition and enforcement on public policy grounds in respect of procedural defects which had already been rejected by the court of the seat. And in that specific context of public policy objections, the court expressed the view, and this is at 1488, C to D, and I'm reading from that paragraph, in a case where a remedy for alleged defect is applied for from the supervisory court but is refused, leaving a final award undisturbed, it will therefore normally be a very strong policy consideration before the English court that has been conclusively determined by the courts of the agreed supervisory jurisdiction that the award should stand. Just as great weight must be attached to the policy of sustaining the finality of international award, so also must great weight be attached to the policy of sustaining the finality of determinations or properly referred procedural issues by the courts of the supervisory jurisdiction. That is in the context of public policy, where there are countervailing public policy considerations between the finality of the award and the reopening of the award on public policy grounds. And Lord, in my submissions, although we don't have to take it up, Lord Hamblin partly addressed this in the RBRG Trading and Cynical case, 2018 1 CLC 874, paragraph 40, page 2469 of the electronic bundle, where his lordship did refer to the finality, the policy in favour of sustaining the finality of awards in the context of a exploration of public policy and whether the court should reopen determinations raising allegations of fraud which were not central to the issues. And it's the same point. And in the Tatneft against Ukraine case, which is at page 2470, this was a case which is in some respects very similar to our case, because that was a case where there were parallel proceedings before the Paris court as the court of the seat and enforcement proceedings before the English court under the New York Convention. The Paris court had rejected a challenge to the award for failing to comply with the arbitral, I'll have to check, but the Paris court had rejected a challenge and Minmetals was invoked for the proposition that you should take into account that rejection. And if we therefore take it up starting at, so you'll see at page 2471, the challenge before the enforcing court, before Mrs. Justice Cockrell, was a failure of the agreed arbitral procedure, because this is paragraph 4, various failures of disclosure by one of the arbitrators. And one of the arguments raised, you'll see this at page 2473, was issue estoppel. That's at paragraph 21 and following. We don't have to look at that. And then at paragraph 32, there was a question is whether the same issue was referred to the Paris court. The court concluded there wasn't identity of issues before the Paris court. You'll see that at paragraphs 34 to 40. And in the context of this, you'll see at paragraph 41, a point was raised by the respondent in relation to the authority of Minmetals. Effectively, you should give weight to the rejection by the supervisory court. And as Mr. EDQC pointed out, that line of authority seems to be one which is developed in the context of public policy objections to enforcement, where the question of balancing account of availing public policy makes perfect sense. There's no analogous authority relied on in this context, and given the nature of issues in play, the impartiality of arbitrators being a fundamental question, I would be slow to find that an otherwise good objection to enforcement should not prevail. And then Mrs. Justice Cockrell goes on to make reference to Dalla and the need for a recognized legal principle. So in my submission, there's no basis, my lord.
It does seem to me that it depends on the nature of the issue, and it might not just be limited to public policy. I mean, suppose that in this case, we have concluded that the governing law is French law. Even if there wasn't an issue estoppel, we might still think it quite important to take account of what the French court had decided on the question.
Well, my lord, I don't disagree with that at all, but I'm conceptually having the following difficulty. If this court had determined that French law were to apply to the arbitration agreement, I question whether at that stage the English court would have then gone on to decide French law issues, or would have, in the exercise of its discretion, considered it to proper to adjourn.
Well, it might, but in Dalla, they did decide the French law issues.
But my lord,
the French court decided them differently. But
they did, my lord.
That's not our case.
But my lord, the reason why that happened in Dalla, as Lord Mance has been at pains to point out, is the procedural situation in which the application to set aside before the French court was issued after the first instance decision on enforcement. So there was a fundamental difficulty. There was an attempt to apply to adjourn at that stage before the Court of Appeal when it was too late. So there was a somewhat procedural difficulty. But I take on board your lordship's point that if the English court was applying French law in a situation where there had not been an adjournment, it may well, even in circumstances outside of an issue estoppel, as a matter of comity principles, wish to have regard to the French court decision.
It's
but of course,
the short point, it's really a very short point, is that the question for the English court is a completely different one from the one the French court was deciding under a different system of law, and therefore it simply is.
Yes, my lord. It is indeed that simple and short, and forgive me for making it I feel that I've been going far too quickly, so I thought I should spend some time on the point. But my lord, that is the nub of it. It's just a different issue. My lords, unless I can assist you further, that is actually a completion of my submissions on the three issues.
I don't see any questions coming from my colleagues, Mr. Dewan, so I thank you very much. And we'll revert to Mr. Che. Mr. Che, you have a full 20 minutes to cover your point.
My lord, I'm grateful. The essential points that I'll seek to cover will relate to the contractual language of the FTA and also to UNIDROIT during the time which I have, and I will rely in respect of issues 2 and 3 principally, as I already have, upon our notice of appeal and our written case. What we say, my lords, is that the respondent's case does not lead to a harmonious interpretation of the language of the FTA. That's the first point. The second point is that it goes against the express language of the FDA by suggesting that the UNIDROIT principles have no real scope for effective application at all in respect of that contract. And so, thirdly, it ends up not giving effect to the express choices stated in the express language of the FDA. And if I might, I'll take your lordships back to bundle page 378 and part of Article 14 of the FTA that we looked at yesterday, and Article 14.3. Now, the four sentences read consecutively are as follows. The arbitrators shall apply the provisions contained in the agreement. Again, I note there that the provisions are in the plural. Secondly, the arbitrators shall also apply principles of law generally recognised in international transactions. And parenthesis there, we know that those are the unidroit principles pursuant to the Court of Appeal's judgment. The third sentence says the following. The arbitrators may have to take into consideration some mandatory provisions of some countries, i.e. provisions that appear later on to have an influence on the agreement. Under no circumstances shall the arbitrators apply any rules that contradicts the strict wording of the agreement. Mr. Dewan, in his submissions, has suggested that the fourth sentence of Article 14.4 is a direct reference back to the second sentence concerning the unidroit principles. But we note that because there are no other rules identified in the agreement that would apply, they are not required, or they do not contradict its strict wording, the unidroit principles. Secondly, the third sentence of Article 14.3 is the sentence which immediately precedes that fourth sentence. And that third sentence says the arbitrators may have to take into consideration some mandatory provisions of countries, i.e. provisions that appear later on to have an influence on the agreement. We say that the fourth sentence is the logical sequitur of that third sentence, and that if there appear later on, per the third sentence, to be any mandatory provisions of some countries or their laws which appear to have an influence on the agreement, then what the arbitrators shall not do in any circumstances is apply any rules that contradict the strict wording of the agreement. Now, as we submitted yesterday, we say that on the express language of the agreement, my lords, it is clear that the parties chose to apply English law, but also unidroit, and those choices, that dual choice of laws, therefore falls within what are to be considered to be the strict wording of the agreement, the choices of those two laws, and fall within the provisions of the agreement equally. We pointed yesterday to the fact that there was no hierarchical language used by these non-English and international parties, and there was no order of precedence prescribed within the contractual language. I should point also to another sentence at 14.4.
Well, Mr. Kay, if you're moving on from 14.3, could I just put my question to you?
I beg your pardon, yes, my lord.
I'm just wondering whether your suggested interpretation works, linking the third and fourth sentences, because the third sentence seems to imply that, or indeed to say, that the arbitrators may have to have regard to mandatory provisions of some countries. Wouldn't it be very strange to say that if you've got a mandatory provision of the public law of some country, that could ever be overridden by a contractual term?
My lord, quite so. But as we know, also there was that strange choice which we discussed yesterday in relation to Article 14.7, which seemed to believe that there could be automatic enforcement. One looks at that language at Article 14.7, which believed that there could be automatic enforcement without any revision of the merits of the case by any court of competent jurisdiction. And so that provision appears to have been inserted by whomsoever drafted this contract without regard to we say, the existence of instruments such as the New York Convention. And
but I mean, just looking at 14.3, the
Yes.
drafter in 14.3 has expressly recognised that there may be mandatory provision of the public law of some countries. So what I'm putting to you is that, that being so, even in the text used by the drafter, does it really make sense to say that the last sentence of paragraph 14.3 is qualifying that sentence rather than the one before?
Well, it may, what I say is, my lord, it may well be qualifying that sentence, because there are certain errors apparently of apprehension concerning how laws would apply, which are, I say, writ large on the face of the contract and the language of the contract, as with the example from 14.7. But in any event, that sentence is not referred specifically to or applied specifically to, for example, my lord, the second sentence of Article 14.3. These are four sentences which are put in consecutively as instructions to those dealing with any dispute which arises, because as we discussed yesterday and as I submitted, 14.7, when read in conjunction with 14.3, demonstrates that these parties, however erroneously, believed that there would be automatic enforcement, that their process in arbitration would be utterly final, and that there could be no review of any sort, whether on the question of enforcement or indeed of the merits of the award. And that was why they thought that the arbitrators would be the only persons who would be likely to be looking at this contract.
Yes, but might it not be said that you start with 14.3 first sentence, sort of standard provision, apply the provisions of the agreement. Second sentence seems to widen that to introduce vague principles. And the last sentence seems to set boundaries that lest that exercise take you too far away from the actual strict provisions of the contract. So it's sort of, you start off with the contract, yes, widen it a bit, but don't go too far. That's sort of the impression it rather gives me the drafters were trying to achieve. What do you say about that?
Well, my lord, what I say about that is as follows. It's clear, as my lord rightly indicates, that the arbitrators must apply the provisions contained in the agreement, but that includes every provision. 14.3 is not cut out of the agreement, those four sentences, and looked at in isolation from the rest of the agreement. That's the first point. The second point is that they are also to apply in the second sentence principles of law generally recognized in international transactions, which, as we know, was found by the Court of Appeal to be unidroit principles. And those principles are therefore not diffuse. They form a body of legal principles which is used and referred to extensively worldwide. As I demonstrated from a quote in the preamble of unidroit yesterday, they are envisaged to be potentially applied to contracts as a governing law. And indeed, we saw this morning when looking at section 46, 1b of the 1996 Act, that they may be applied as the governing substantive law of the contract, whether in addition to another law or not. And so I say that it can't be the case that the fourth sentence means that the parties or that the arbitrators should not go too far, as long as they are consistent in their application of English law and unidroit principles, because there's no internal hierarchy which is prescribed between English law and the unidroit principles. And it can't be, we say, that they are only of application or might only be of assistance concerning any dispute or question under this contract, so as to look at a small provision in Article 3 or Article 4 or Article 5.2, as my learned friend suggested. They must have been intended by the parties to have more general application, because that is the language which is used in terms of also apply at 14.3 second sentence. And they must be given effect, we say, because they are the express language or linguistic choice which was made by the parties to the FTA. My Lord, does that assist?
Yes, thank you very much.
And if I might just go on briefly to Article 14.4, one notes there that there's language which permits the fact that, for example, the licensor, that's the appellant, might be able to seek and obtain a temporary restraining order or preliminary or permanent injunction or other equitable relief from a court of competent jurisdiction under any applicable law. But one then notes, and of course sees, either a typographical error or a linguistic error by these non-English international parties, all remedied, which I suggest means remedies, provided in this agreement, are cumulative and not exclusive of any remedies provided by law. So there's at least the express language of cumulation within the agreement in terms of the types of remedies which might be provided. Now, those remedies, according to the language of the contract, are remedies which are available at English law and also unidroit by way of the laws applicable to this FTA and similarly to the FOAs. My Lords, might I now go please to unidroit very briefly at page 1423 in the bundle. My Lord Legate put a question to Mr. Duran during his submissions concerning what use unidroit might have. Now, thinking as we must about Article 2 of the FDA and indeed of Article 14.3 second sentence, which clarifies, perhaps we say, why the particular language of good faith and fair dealing was used at Article 2, which I've said is, of course, consonant with and synonymous with the, or exactly the same as rather the language, an expression of Article 1.7, or Principle 1.7 of unidroit. I want to look at Article 4.1 of unidroit concerning interpretation briefly, which says that, of course, the contract shall be interpreted according to the common intention of the parties, and if such an intention cannot be established, the contract shall be interpreted according to the meaning that reasonable persons of the same kind as the parties would give it in the same circumstances. Now, if one moves on to page 1426, one sees Article 4.3 of unidroit. The question was put by my Lord Legate this morning to my learned friend as to whether, for example, preliminary negotiations might be a relevant factor in respect of unidroit. Well, my Lords, under unidroit, the relevant circumstances do include at A, preliminary negotiations, but they also include, and this is relevant to the factual section of our written case and the facts presented to you this morning, they include B, practices which the parties have established between themselves in terms of performance, for example, of contract. C, the conduct of the parties subsequent to the conclusion of the contract. D, the nature and purpose of the contract. E, the meaning commonly given to its terms and expressions in the trade concerned. And F, usages. We say that C is important, as is B. There appears to be no rule under unidroit which prevents subsequent conduct. because of the core principle of good faith and fair dealing, from being something which can be taken into account in order to interpret a contract to which unidoir is applied. And this is a contract to which unidoir should be applied as a result of the express language used by the parties. If I might now go to page 1418.
Just before you move on, I don't understand that last submission, Mr. Chair, that there's no issue of interpretation that's been identified or any subsequent conduct that might affect such an issue of interpretation. Just seems to me a red herring on the issues in this case, unless I've missed something completely.
My lord, we say that it's relevant in terms of the types of, in response to your question this morning, in terms of the application of unidoir concerning the contract. I'm not addressing it to the specific issue, for example, of estoppel, which arises, we say, through the conduct or preclusion rather under unidoir, which we say arises through the conduct of the respondent.
I see. Well, I misunderstood. I thought you were addressing this particular case. It's just a theoretical point.
Well, my lord, it's to demonstrate the way in which the good faith interpretation, which is required by Article 2 of the FDA, might be applied. In respect of Article 2.1.18 at page 1418 of the bundle, I note that there is a specific provision in unidoir concerning modification in particular form. This is a provision that was relied upon by the arbitrators and cited by them at paragraphs 203 to 206 of their decision when applying the unidoir principles, and stating, of course, the NOM point, as we call it in English law. And what is interesting is that it says a contract in writing which contains a clause requiring any modification or termination by agreement to be in a particular form may not be otherwise modified or terminated. However, a party may be precluded by its conduct from asserting such a clause to the extent that the other party has reasonably acted in reliance on that conduct. And so the appellant's case, both in respect of the arbitration agreement contained, not in respect of the FDA and whether the respondent can have become a party to the FDA if English law and unidoir apply as per the contract, is that it may have become a party because it may be precluded by its conduct from asserting that it has not become a party. Now, in that respect, finally, on 2.1.18, I'd like to take you to page 1419 and simply draw your lordship's attention to the illustration 2 at the bottom of that page, which we say is my Lord Sales.
Yes, I'm so sorry. I'm just puzzling over what you've said about Article 2.1.18. Why wouldn't that be something which would be contrary to the strict wording, to use the language in the fourth sentence of Article 14.3 of the agreement, because of the strict wording of the NOMS provisions in the agreement?
My Lord, despite the strict wording of the NOMS provisions in the agreement, I think there are 2 points in that respect. Firstly, although there are no modification clauses, those are something which are provisions of the agreement, just as Article 14.3 second sentence is a provision of the agreement, and therefore unidoir is also to be applied in addition to English law. And if the unidoir principles effectively form part of the agreement and are to be applied to it, then they conceive of situations where, if a party's conduct, for example, if it's lack of faith, good faith and fair dealing, its conduct demonstrates that it should be precluded because it's behaved inconsistently under Article 1.8 of UNIDROIT as found by the arbitral tribunal, then that party may be precluded from contending that it hasn't become a party, notwithstanding the existence of the no oral modification clauses. And that conduct, as a matter of the UNIDROIT principles, there is no requirement under the UNIDROIT principles that the conduct necessarily be unequivocal, because it's accepted and envisaged by those principles that, for example, one may sometimes be silent and behave inconsistently in order to obtain a particular advantage.
Yes, thank you.
Great, my lord. If I might simply now go to finally to page 1405.
Yes, I'll have to invite you to wind up your submission because you are now outside your time. But topically, you might say you're in injury time.
My lord, I'm grateful for that indication,
Yes.
and I will wrap up
Yes.
presently in the next 2 minutes.
Thank you very much.
Article 1.7, which is at page 1405 of UNIDROIT, is the provision concerning good faith and fair dealing, which is in the same language as I submitted yesterday as Article 2, providing for good faith and fair dealing in international trade. But if one turns on, one sees at page 1409, Article 1.8, which is precisely what the arbitrators relied upon in conjunction with 2.1. Because what they found, applying UNIDROIT, was that there had been inconsistent behaviour, which is something which falls beneath the standard of good faith and fair dealing, which is expected of a party under the UNIDROIT principles by Article 1.7, but was expressly expected of any party to the FTA by Article 2. And that provides simply that a party cannot act inconsistently with an understanding it's caused the other party to have, and upon which that other party reasonably has acted in reliance to its detriment. And with that, my lords, I think injury time is now over.
Mr. Shea, thank you very much. Well, the court would like to thank both counsel for their submissions and also those who have assisted in the preparation of the submissions and also the papers or the virtual papers for this appeal. I apologise for the problem starting yesterday morning, but I'm glad that we were able to accommodate the full hearing by extending this appeal into this afternoon. The court will consider carefully the submissions which parties have made and will seek to produce a judgment in as early course as is possible. Thank you all very much. The court will now adjourn.